I want to talk about Judge Boasberg. Here's a statement by President Trump about Judge Boasberg just a few days ago on March 18th. This radical left lunatic of a judge, a troublemaker and agitator who was sadly appointed by Barack Hussein Obama, was not elected president. He didn't win the popular vote by a lot. He didn't win all 7 swing states. He didn't win 2,750 to 525 counties. He didn't win anything. I won for many reasons, an overwhelming mandate. But fighting for illegal immigration may have been the number one reason for this historic victory. So he's talking about Boasberg here because Boasberg, of course, is the judge that's presiding over the Alien Enemies Act case, in which Trump has proclaimed Tren de Aragua to be a terrorist organization, to be a quasi-military arm of the Venezuelan government, and engaged in a predatory incursion of the United States. And under the terms of the Enemy Aliens Act, which Congress passed to grant the president, the Article 2 executive branch president, this authority, Trump can summarily grab people who meet those classifications and summarily deport them from the nation. Now, in his proclamation, he defined who falls within the class of people subject to this deportation. And there's really 3 criteria he defined. Well, 2 he defined, 1 is inherent to the act. So the act only ever applies to people who are 14 years of age or older. That's it. So you have to be 14. And then Trump added the class of people who are engaged in this predatory incursion are members of TDA, and the proclamation does not apply if they happen to be a U.S. citizen. So those are the 3 criteria. You're a member of TDA, you're 14 years of age or older, and you're not a U.S. citizen. You're subject to the proclamation of the Alien Enemies Act. Now, again, Trump is not a fan of this guy Boasberg. There's lots of reasons not to be a fan of Judge Boasberg, by the way. He's been involved in lots of, I guess I call it sketchy rulings. He is a District of Columbia District Court unelected, tyrannical, black robe trial judge, was involved in a lot of the January 6 prosecutions, desperately wanted to give those people longer sentences than the law permitted him to do. He gave speeches about it. And just yesterday, he had already issued an injunction in this case, prohibiting Trump from deporting anybody under the proclamation of the Alien Enemies Act, any TDA member, nationwide, created a nationwide class, and Trump had asked them to stop that. Stop preventing us from deporting these TDA terrorists. And the judge said, nope. I'll just read a little bit of his opinion from yesterday here. See if I can make this a little bigger for everybody. Looks like that's about as wide as I can go. How's that look? I'm not going to read this whole thing, just the first couple pages where the judge kind of sets out his premise here. And how he characterizes Trump is very funny too. All right. Let's see. Oh, that's better. That's better. I'm trying some new stuff here for everybody. All right. So this is a memorandum opinion of the judge. Imagine the worst has happened and you've been compelled to defend yourself, your family, or your property from a criminal predator. Fortunately, you win the physical fight, but now you have to also win the legal fight that follows. The cost of that legal battle can be enormous, easily hundreds of thousands of dollars. And trust me, how much money you can bring to the legal fight really does affect your chances of being found guilty or not. The good news is that you can guarantee you have the resources you need to be hard to convict with the backing of CCW Safe, a provider of legal service memberships. There are various self-defense insurance companies out there, and some of them are horrifically bad. CCW Safe is the one that I most trust to protect me and my family. I'm personally a member, and so is my wife. I urge you to learn more about why I trust and choose CCW Safe for myself and my family by pointing your browser to lawofselfdefense.com/trust. And at the same place, you'll find a discount code to save 10% off your membership at CCW Safe as well. In the pre-dawn hours of March 15th, 5 Venezuelan non-citizens being held in Texas, that's important, by the Department of Homeland Security sought emergency relief in this court. They feared they might be removed from the country pursuant not by the Immigration Nationality Act, but instead the Alien Enemies Act of 1798, a law last invoked in the wake of Pearl Harbor as the nation was preparing for war. That act authorizes the president to summarily remove native citizens, etc., of a hostile nation or government when there is a declared war or, and this is important, invasion or predatory incursion. It's this latter that Trump is claiming, not war, obviously. The president, plaintiffs believes, had secretly signed a proclamation invoking the act. Well, and upon its imminent publication, the government would immediately remove them. Well, before something's published, it's always secret, right? So he makes this sound like it's such a horrible thing. The president signs something and then they publish it. That's perfectly normal. As expected, later that day, the president indeed published a proclamation announcing that because TDA, a violent transnational criminal organization, had committed a predatory incursion upon the U.S., the government could begin immediately deporting any Venezuelan non-citizens it deemed to be members of Tren de Aragua. Plaintiffs are among those so deemed. But wait, they protest. The government's mistaken. Each vehemently denies being a member of Tren de Aragua and thus subject to the proclamation. Several, in fact, claim they fled Venezuela to escape the predations of TDA. Interesting. So they sought a temporary restraining order preventing the government from deporting them without a hearing. This was issued by the court, 2 temporary restraining orders. One of them was verbal and one was written, and they were not the same, which allowed the Trump White House to deport several hundred of people under the proclamation here. Let's see. Neither order required the government to release anybody from custody, so they weren't a threat to the community. Neither order prevented the government from apprehending anyone, so they could detain them under the proclamation. And neither order prevented the government from deporting anyone, including the plaintiffs, if they had a cause other than the proclamation. Indeed, last month, the president designated Tren de Aragua a foreign terrorist organization, so they're already inadmissible and therefore deportable under the Immigration Nationality Act. The government now asks me, this Judge Boasberg, to vacate the TROs on the grounds that there is not sufficient likelihood the plaintiffs will succeed, and the president's unprecedented use of this act outside the typical wartime context. This is deceptive because the act itself says it can be used beyond wartime, raises sensitive questions. A lot of issues, but this court does not need to resolve these questions about whether the judiciary has the authority to answer these questions because plaintiffs are likely to succeed on another equally fundamental theory. Before they may be entitled, they are entitled to individualized hearings to determine whether the act applies to them at all. As the government itself concedes, the awesome power granted by the Alien Enemies Act may be brought to bear only on those who are, in fact, alien enemies. And the Supreme Court and the circuit have long maintained that federal courts are equipped to adjudicate that question when individuals threatened with detention or removal challenge their designation because the named plaintiffs dispute they are members of Tren de Aragua. They may not be deported until a court has been able to decide the merits of their challenge. Now, what does this all mean? Could the judge be right about this? Now, I'm no fan of Judge Boasberg, but the fact is, the judge probably is right on this point because the Alien Enemies Act itself says that there is a due process involved here. There we go. An act respecting alien enemies passed in 1798. Now, everybody in the U.S., folks, is entitled to due process of law. Everybody, whether you're here illegally or legally or citizen or non-citizen. Every criminal, every murderer is entitled to due process of law. The question is, how is due process defined in any particular context? Because it's not some kind of flat process that applies to everybody in all circumstances. The amount of due process any of us are entitled to, or let's say an American citizen is entitled to, if he's charged with murder, is vastly greater than the due process you're entitled to if you're arguing a ticket in traffic court. It's not the same due process. Due process varies depending on the circumstances, the severity of the charge, your status in society. Another example, the due process I, as an American citizen, am entitled to before I can be deported from the U.S., it's much greater than the amount of due process that a criminal migrant is entitled to before they can be deported from the U.S. I get more due process versus deportation than Mahmoud Khalil, for example. We'll talk about him in a show soon. There's stuff happening with him too. And it's also true that these Trende Arago guys are going to have much less due process than me, or even a typical illegal migrant, because they've been declared terrorists. But that doesn't mean they get no due process. Everybody who's been seized by the government has at least the due process of a habeas corpus motion, which is a request to a federal district court saying, hey, I've been grabbed by the authorities. I don't think me being detained is lawful. I want an opportunity to appear in court and compel the government to explain why my detention is lawful. That's what a habeas hearing is. And these guys grabbed under the Alien Enemies Act are entitled to a habeas hearing. Anybody who's been grabbed is entitled to that. We don't run secret police here in America. But the due process they're entitled to at that habeas hearing is very limited. It's limited to, do they meet the criteria of the proclamation? Are they TDA, or should I say, because we don't have to know anything absolutely, does the government have good reason to believe they're TDA? Does the government have good reason to believe they're 14 or older? Does the government have reason to believe they're non-citizens? So whatever the conditions are defined in the proclamation that triggers, that invokes the Alien Enemies Act, that's what these guys are entitled to in terms of due process at a habeas hearing. In fact, the Alien Enemies Act tells us this. We go down to Section 2. After any proclamation is made, let's see, let me do this. So after the proclamation is made, it shall be the duty of the several courts of the United States authorized upon such complaint, someone's been grabbed, against any alien or alien enemies who shall be present and at large within such jurisdiction or district. I'll come back to that in a moment. Let's see, to cause such alien, here we go. This is the due process. To cause such alien or aliens to be duly apprehended and convened before the court, and after a full examination and hearing on such complaint. In other words, does the person qualify as falling within the proclamation? And if they do, in this case, does the government have good reason to believe they're TDA? Does the government have good reason to believe they're 14 or older? Does the government have reason to believe they're not citizens? If they meet those conditions, and the government can be compelled to demonstrate that at a habeas meeting, they shall be ordered to be removed out of the territory of the United States. So it's non-discretionary. But they do get to compel the government to make that case at a habeas meeting. Here's the trick, though. It's supposed to be done in a court in the jurisdiction where they've been duly apprehended. So these TDA guys are detained in Texas. So they can demand a habeas hearing, but the proper venue for that habeas hearing is not a federal district court in the District of Columbia. It's in a federal district court in Texas. So this court in District of Columbia, Judge Boasberg's court, has no jurisdiction for this kind of hearing. So when the judge says, I don't have to worry about all the nitty-gritty details about the law, the immigration law around this right now, whether I generally have authority to settle these complicated issues, because all these TDA guys have at least a right to the habeas hearing. And that's true. What he's missing is they have a right to a habeas hearing in Texas, where they may very well get a very different type of federal district court judge than they get in the District of Columbia, which is overwhelmingly packed with liberal district court judges. So, what else do we have to say about all of this? I do have more. Move this over. Now, of course, one of the consequences of all this, by the way, has been that there are movements now to impeach Judge Boasberg. Representative Brandon Gill has filed articles of impeachment against this activist judge for high crimes and misdemeanors. Now, how effective that all is can be questionable. Here's the actual impeachment document. I don't think I'll read it here. The problem, of course, for impeachment is you need a majority of the House to impeach, and you need 2/3 of the Senate to convict. And I don't think that's feasible, because the Republicans don't have 67 votes in the Senate. So impeachment seems like a bit of a pipe dream. I've talked many times about the alternative to impeachment, which is being removed for failure to serve during good behavior, which is a condition of tenure for federal judges as defined in Article 3, Section 1 of the Constitution. So I did run a little poll on X. Do you think Judge Boasberg in the Alien Enemies Act TDA deportation lawsuit should be impeached? 5% of you think he's a fine judge. I don't know where you people come from. I always put the worst choice as number one, and a bunch of you invariably choose it. 30% of you say he should be impeached, and 65% say removed for bad behavior, because I think you've heard me talk about this before. The prospects for impeachment are basically zero, but the prospects for removal for bad behavior, much more promising. And even if it turns out, because we've never done a removal for bad behavior before of a federal judge, a process needs to be created. I think an appropriate process is simply a majority vote in the House and the Senate. That would be consistent with having a alternative to impeachment specified in the Constitution that doesn't require the severity of accusing someone of a high crime and misdemeanor. But even if we don't get it done, the threat of this much easier, much more expeditious check on these federal judges, the risk that they could actually lose their jobs, and this is their dream job, folks. This is being a federal judge. You don't work that hard. You're fairly well paid. You have good retirement, and you're not paid as much as you would be paid if you were a partner in a big law firm. But of course, you get your wife one of these NGO jobs. You get your adult kids these USAID money laundering jobs. So you can pad your income pretty effectively if you're a creature of the deep state swamp, as all these federal judges in the DC circuit are. So 95% of you at least believe he should be removed. I did a YouTube survey, 2 very similar results, almost identical. Oh, even better. 97% believe he should be removed. So what are the implications of all this for this judge? For this judge. Now that, I have to get to the secrets. To the secrets. I almost forgot. That would have been silly of me. The state invocation of the state secret privilege. So let's pull this up and talk about this. Here we go. Filed yesterday after the judge declined the stay his own injunction against the Alien Enemies Act proclamation. So notice invoking State Secrets Act. The executive branch, the White House, notifies this court that no further information will be provided in response to the court's demand for details on how these exportations of TDA are being done. This is a case about the president's plenary authority under Article 2 of the Constitution and the mandate of the electorate, the American people, who collectively elected President Trump to be the Article 2 executive branch president, endowed with 100% of the executive authority of the United States, reinforced by a longstanding statute, that's the Alien Enemies Act of 1798, to remove from the homeland designated terrorists participating in state-sponsored invasion and predatory incursion into the U.S. This court has all the facts it needs. We're telling you what facts you need, Judge, to address the compliance issues before it. And by the way, the White House concedes that anyone to be deported under this Alien Enemies Act proclamation does in fact have a right to a habeas hearing. They just argue that it should be very summary. It's not expansive. It's only those 3 questions. We have reason to believe he's TDA. We have reason to believe he's 14 or older. We have reason to believe he's a non-citizen. That's it. And those habeas hearings should be held where the person's being detained, in this case, Texas. And of course, they're raising all kinds of separation of powers concerns here. Further intrusion on the executive branch by the judicial would present dangerous and wholly unwarranted separation of powers harms with respect to diplomatic and national security concerns. Virtually all national security interest is bestowed on the president under our Constitution. A little bit is reserved for Congress. But in this case, Congress, in passing the Alien Enemies Act, took whatever share of national security concerns they had on this issue and gave it to the president. The state secrets privilege forecloses further demand for details that have no place in this matter, and the government will address the court's order to show cause tomorrow by demonstrating there is no basis for suggestion of non-compliance with any binding order. Okay, I'm not going to read the whole document. You get the idea there. So the judge is going to have to make his rulings now without any more secret information from the executive branch of the government. Now, I presume, because this judge is extraordinarily hostile to President Trump, as Trump is hostile to the judge, that the judge is going to rule negatively for the president on this Alien Enemies Act stuff. But that just means it will all become appealable. It will all become appealable, and we'll begin to work our way up the chain of responsibility to ultimately to the U.S. Supreme Court, which of course is also not operating very effectively right now. I'm not going to address that this week. I will address the Supreme Court in more detail next week